is on the basis that the same has been linked to the affidavit sworn in petition 015. Paragraph 16, that Lady Justice Mugambi is conflicted as she should recuse herself, as she was Mr. Kindiki's LLM student at Moi University.
We have no LLM program at Moi University.
Professor, you will have your time to submit, sir. Stop itching. And that's why I'm expunging it. That's why I'm expunging this paragraph. That is what my client said. A crucial issue that she failed and or refused to disclose to the parties. My client has learned that she was not an LLM there and that she only took her degree in that university.
We have no objection to anything being expunged, subject to the court observing that if this witness has lied about these two issues, what else has he lied about?
In a ruling, because application has been made and the response is there, but we decline the invitation to expunge those paragraphs. They will remain as part of the record.
You are so right.
Dr. Kamuna, we would appreciate if you want to address us in the course of the as in you are submitting. Is that the position?
Yes, that's right.
Okay, proceed.
My other position, no question is that there is a party.
Are you supporting the motion?
I'm supporting my land friends complaint to Ndegwa and Njiru as my land friend is actually.
We need to go. Yes,
Oh, yes. Yes.
Thank you very much to my senior. My lords, I'll take about 15 minutes. Mercifully, my issues are issues of law. They will not incite any shooting up from respondents, or should not. My lords, my lords and your leadership, I have submitted some two cases. The first case is the case of Standard Chartered Financial Services and another versus Manchester Outfitters. I don't know that you have that with you. And the second is a case called Naveen Premjikerai versus Virunga Limited and others. In the case of Standard Chartered Financial Services Limited versus Manchester Outfitters, and this remains, as far as I'm aware, the first case where the Court of Appeal reviewed a judgment, a concluded judgment, set it aside and varied it. And the only question before that court that led it to this decision was the question of bias. I invite my lords and your leadership to paragraph 1 of the decision, where the court says as follows in trying to frame the seriousness of the issue. And I'm reading from the second line. It is a rare application in which the applicants seek to have the judgment of this court reopened, re-examined, declared nullity, set aside, and the appeal heard afresh. I invite you now to go to paragraph 9. We've done back-to-back photocopying, but if you look at paragraph 9, in the middle is in bold the words Jasbir Singh Rai and two others versus Talokan Singh Rai. And the court is saying what it held. And it says this. During the pendency, my lords and your ladyship, are you there? In the middle of paragraph 9. During the pendency of the applicant's motion and the respondent's preliminary objection, this court in a 5-judge bench decision in Jasbir, and they give the whole case there, held inter alia, that it was only mandated to hear and determine appeals from the High Court and could not revisit its own previously concluded decision, nor did it have powers to reopen and rehear a finally concluded matter. In light of the decision in the Rai case, it was deemed appropriate that since this matter raises similar issues, it be similarly heard by a 5-judge bench, hence the unusual composition of this bench. They are merely underlining the importance of the matter the court was dealing with. Permit me now, your ladyship and my lords, to invite you to paragraph 63, where the question that vexes you this afternoon is dealt with. At paragraph 63, they deal with a case which we've also supplied the court and my friends with. This is a well-known case of Senator Agostino Pinochet. But at paragraph 63, this is what they say. Bias, whether it is perceived or actual, undermines the public confidence in a judicial officer's ability to dispense justice. They then cite a caption by Lord Joff in R versus Gao. Justice must be rooted in confidence, and confidence is destroyed when right-minded people, the right-minded people that Mr. Ndegwa was talking about, go away thinking the judge was biased. At paragraph 65, the case of Webb versus Queen, in considering the merits of the test to be applied in a case where a juror is alleged to be biased, it is important to keep in mind that the appearance as well as the fact of impartiality has been done. And this is what they say at paragraph 66. And this, my lords and your ladyship, is what I would be beseeching this court to find favor with when you retire to do your ruling. The rule against bias is as important an element of the right to a fair trial. This rule, and now this is our own 5-judge bench saying this in the Court of Appeal, this rule is to be very strictly applied so that even the appearance of bias is done away with, the appearance alone. This is because it aids in public confidence in the fairness and impartiality of the judicial system. In view of the jurisprudential importance and uniqueness of this application, they then cite a case called R versus Sussex. Justice should not only be done, but should manifestly and undoubtedly be seen to be done. I will leave for you to read paragraph 67, which I also recommend to you. And then paragraph 71, another English case cited. First, actual bias will of course always disqualify a person from sitting in judgment. Even in the absence of actual bias, however, the importance of public confidence in the administration of justice is such that even the appearance of bias will disqualify. And they say emphasis added. And I would also invite you to look in the fullness of time to paragraph 73 and 74. Paragraph 81, they cite the case cited